and that's to do with the Senzo Meyiwa murder trial, which continues today. The state's third witness will now take the stand, and while the identity is not yet known, it's understood that the witness was present in the house on the night of the murder. The late Orlando Pirates and Bafana captain was shot dead at the height of his career, this back in 2014. 5 men are on trial for the murder, and eNCA reporter Slindelo Masikane is following the trial for us and joins us now for an update. Slee, you gave us some context that has to do with just yesterday's postponement and not so many being happy about this.
Of course, we resume today with what was supposed to happen yesterday, Dumelo, and that is, of course, the state's third witness being sworn in to give their testimony and account of what happened on that fateful evening. We know, of course, that while we can't reveal who this third witness is, because at any moment the state could change their mind, we have some information around the fact that it was someone who was present on that evening, someone who was in the house. But to give us some more analysis and unpack the proceedings that we're going to see this week, I am joined by legal expert once more. That is Mr. Marius du Toit. Thank you so much for your time this morning. Once more, Marius. Let's just start with the state. Morning. Let's just start then with the state postponing the trial to this morning, asking for an overnight postponement, citing reasons around the fact that they couldn't secure flights for the witness who's supposed to be sworn in over the weekend. Are these reasonable? Is it justifiable? Because from my understanding, the state, as well as the investigating officer, are supposed to ensure that a witness is available for a court sitting.
Yeah, Slee, first and foremost, we must remember that the state is dominus litis, and they are the ones trying to produce evidence sufficient for the court at the end of the day to pronounce a verdict. And any party who calls a witness has to ensure that this witness is at court. Typically, the court would ask the state, did you subpoena this witness timeously? If this witness was timeously subpoenaed, the court will then investigate to find out why this witness was not at court. If a plausible explanation is given, the court would normally grant an indulgence and normally postpone the matter, provided it does not encroach upon the accused's right to a fair trial and a speedy trial. And at the end of the day, you just want the matter to be finalized. So should it happen that a witness not be able to come to court because of flight delays or difficulty getting a flight, that in the circumstances could be reasonable for one delay. And I think if the same application is made today, the court might be reluctant a second time to say to the state, well, listen, if this witness couldn't be procured over the weekend, we are now heading towards Wednesday. This witness is still here. Are you still persisting that you're having travel arrangements with this witness? If this witness had utilized the vehicle, he would have been in Joburg by now or Pretoria by now. So the delay becomes unreasonable if it's too long or if there's no justification for it.
Now, of course, the defense, Marius, had objected to the postponement, saying that the state was, in fact, using delay tactics, saying that there were a number of witnesses who were in the house who are actually based in Johannesburg. In fact, we heard from the defense from accused 1 to 4, that's TT Tobane, telling the court to note that if the witness doesn't arrive today, then it would invoke, if I'm not mistaken, Section 342A of the Criminal Procedure Act. Can you just maybe take us through what that particular section is about?
Yeah, so this section was brought about a couple of years ago in order to prevent the unnecessary delay in court proceedings. So the moment one of the parties to the matter believes that the other party is delaying the proceedings, they firstly, and if it's the defense, they have to give notice to the state by standing up and saying to the court, Your Worship, or Your Honor, or My Lord, at the end of the day, this matter is being delayed, and I think it's purposefully being delayed by the court, and I want you to investigate, and should they not bring this witness, we want you to invoke this section and then give an order that you deem fit in the circumstances to ensure that this delay doesn't hamper my client's right to a speedy trial. And the court can give any order it deems just in the circumstances to expedite the matter, and it's quite an invasive section if the state, for argument's sake, let's assume this is the last witness that the state has and they want to delay, and for whatever reason the court finds that the delay is their fault, and this matter is now being delayed once again, the court can even, upon notice being given by the defense, they can even go so far as to say, I deem your case closed at this stage because of this unnecessary delay, and I order that this matter now proceed. And then the state case will be deemed closed. So it's a very invasive procedure. It's a procedure that is often invoked in criminal courts. And the whole purpose behind it is just to ensure that no party is prejudicing the other party with an unreasonable delay in the proceedings.
Lastly then, Marius, let's just canvass just how crucial this evidence is. This person who was in the house, who's going to give us their account of what happened. We have seen on numerous occasions that the defense is pushing to get that testimony rolling, but it seems the state quite hesitant to tell us exactly who they're going to be calling.
Yeah, so Slee, we have to remember that the state has quite a number of evidentiary material and ways of trying to prove the guilt of the accused. One could be circumstantial evidence. That's when you draw inferences from things that were discovered at the crime scene or things that happened. You can have direct evidence, which is probably, in this instance, a witness that was present at the scene, who was able to see what happened, is able to identify the accused if he saw him at an ID parade later on. You could have forensic evidence, which is ballistic, fingerprints, that sort of thing. So if you have, you would always go to adduce the best evidence available. So if you have a number of witnesses in the house, the state does not need to call each and every witness there is, but they need to adduce evidence sufficient to say to the court at the end of the day, from the evidence that we have adduced, we are satisfied and we argue that we've made out a case which the accused must answer to. We've made out a prima facie case and the accused must now present his case to the court. Should the state not call a witness, so let's assume for a moment, Slee, that for whatever reason the state decides they're not calling anybody in the house, then the defense can argue the failure by the state to call an essential witness, and we know this witness is a witness that was in at the night or at the day in question in the house, prejudices the state, and they want the court to draw an adverse inference from the failure of the state to call a witness. So the defense can argue to the detriment of the state that we want you to draw an inference to say the reason why they didn't call this witness is because this witness is maybe favorable to us and not favorable to the state. So at the end of the day, the state has a duty to adduce the best evidence. They must decide what is the best evidence because they're dominus litis and they're in charge of the way the evidence should be adduced before court. But ultimately, when it comes to the trial itself, they have to ensure that these witnesses that testify are witnesses that in fact saw and can add value to the matter. And if this witness doesn't add value, well, then you don't call him. But still, if it's a crucial witness, and it's a witness that maybe saw the suspects the night in question, that's able to maybe put the accused at the crime scene or at least give a description of the clothing they were wearing, if they fled the scene. So, that evidence is very important for the state. And a failure to do so could easily invoke a negative inference from the court, should the defense argue that.
Just quickly, Marius, is it significant that there was no ID parade that was done for these 5 men who are on trial?
So, yeah, Slee, so normally if you have an eyewitness or direct evidence of somebody that was at the crime scene that saw the suspects, in their statements, these witnesses will normally state, I'm able to identify these people should I see them again. Or the witness can state in his affidavit, even if I see them again, I won't be able to identify them. Now, typically, if you're the prosecutor or you're the investigating officer, and the moment you understand that there's a possibility that this witness could identify one of the suspects as being the perpetrator, well, then you have to hold an ID parade to ensure that when you have 8 people for one accused, that the witness has a reasonable opportunity to pinpoint the person that he said was present at the scene. But it would serve no purpose, Lee, if this person's argument says, I didn't see that, I couldn't identify them if I see them again. Then there's no value to that. But of course, we have to also remember the following. If I say, for argument's sake, listen, I can identify you because we know one another and we've spoken to one another often, then it serves no purpose to hold the ID parade because we know one another. But the moment you have a witness that says, I do not know this accused, but he had very distinct features, I have had people with scarring in the face. I've had people with a distinctive hairstyle. So you would often have that when the witness is able to say this person had something distinct in his face that could easily make him recognizable if I see him again, then you would typically want an ID parade or something like that so that this witness has a reasonable opportunity to say, between 10 or 12 or 15 people, I was able to pinpoint this person as being the accused in the matter or the suspect that I saw the night in question.
All right, thank you so much for your time this morning. That is legal expert Marius du Toit unpacking the proceedings that took place yesterday and the postponement. And of course, we are expecting court proceedings to resume at 10 a.m. this morning. We will be bringing you those visuals live here on DSTV 403. It's back to you in studio.